May be seated. Before the court, the matter of People versus Brian Lindsay. Today is a continuation of the preliminary examination. Counsel, waiting for Mr. Muhammad.
He was just here.
For the record, while we're waiting for Mr. Muhammad, Counsel.
Good morning, Your Honor. Ted Wallace, P80922. On behalf of Mr. Lindsay. Mr. Lindsay, please state your name.
Brian Lindsay. Mr. Wallace, this was scheduled for 10 o'clock. It's 11. Where have you been?
I've been in the parking lot on Zoom with the Third Circuit Court, Your Honor. As the court knows that this was not scheduled originally to be here. I've had
a week scheduling. Were you too busy to be here?
I wasn't too busy to be here. I was in the Third Circuit Court on Zoom with Judge Cynthia Miller, and I was not able to come in. I've both told the APA, Mr. Muhammad, and I've returned 2 emails to the clerk explaining that I was there, and as soon as I was able to make it in, that I would.
That was this morning from the parking lot?
I've been here.
In advance, and probably weeks in advance that you had to be evidently in 2 courts.
Well, Your Honor, and I tried to explain that when this was rescheduled, and I explained that not only did I had an AOI that was scheduled by Judge Miller, I also had a preliminary exam scheduled for Allen Park. I tried to explain that when I was given this date. I did say that I would do the best I could to accommodate the times that were given, but I did have this come up, and I explained in the email. I told Mr. Muhammad, and I explained that I was doing the best I could with the short notice on this.
Yes, Your Honor, and good morning, Your Honor. Muhammad, on behalf of the people. Mr. Wallace has been in communication with me, and he's, to the best of his ability, tried to be here on time, and since the beginning of this case has always reached out. So I appreciate that, and I have no doubt that this is just a mistake.
Last time I checked, the courts at the time, evidently the parties had agreed to do something else and left us all hanging. That's not the way to do business. All right. Having said that, let us progress. Today is a date set for a continuation of the preliminary examination, and perhaps a ruling by the court if there's nothing else left to present to the court. When we left, once again, it was almost, I hate to say rush. We stepped for the morning. We got a late start through no fault of the court. And then we broke about 1 o'clock. As Mr. Wallace had some other courts you had to attend to. So we terminated the proceedings with a summary, or for want of a better term, argument with respect to a motion to bind over. Since that time, the court has had an opportunity to review the evidence presented to the court. I have some questions, but between then and now, has anyone reviewed anything they wish to present to the court now before I make a ruling, if we can't make a ruling today?
Yes, Judge, if it's okay with Your Honor, I'd like to just briefly summarize what we heard and how I saw it from my point of view, if that's okay with Your Honor.
Yes.
Thank you. So, Your Honor, during the lengthy preliminary examination, we had the opportunity to hear the testimony of a number of individuals. And one of those individuals, Miss Catherine Honke, which is the girlfriend of the defendant. She identified the defendant of being the driver of this blue Jeep Wrangler that was in question, that was demonstrated through the footage that was presented to the court. She was able to identify the defendant as being the driver. She also provided us with information that the defendant was in question with a handgun on that particular day. She described it as a black handgun. She informed us that it was only her and the defendant, Mr. Brian Lindsay, that made that location inside of that vehicle. The narrative that I believe that
Arrived at the location.
Arrived, correct. Thank you, Your Honor. The narrative that the defense was essentially pushing, which is what I gathered, was that the defendant was there picking up his girlfriend so that they could leave the bar. This is around 4 a.m., and that is the narrative that was being pushed. However, through the course of the preliminary exam, Your Honor, you had an opportunity to review the footage in this case. And from my review, there was numerous times where Ms. Honky could have entered into this specific vehicle and exit the premises. At one point, that vehicle door, the passenger door, was open. Despite that, she did not enter into the car and exit the location. She then went to the back where there's a group of individuals standing. She, I believe, put her hand on Mr. Dennis Keewan, or yes, Miss Honky, and at some point after that, the defendant had reversed again abruptly in a manner that I would describe as a bully acting in a way with a vehicle. He did not, the defendant, Mr. Brian Lindsay, who was operating this blue Dodge vehicle, Jeep, did not just reverse once or twice. There was multiple occasions where he would reverse, pause, and at one point reverse very abruptly in a manner where he's trying to let those people know that are occupying that parking spot that I can take it over because I'm in the car. And to me, that describes a bully. And the way I see it is he's using his vehicle in a manner to push people out of the way because he knows he's in a vehicle. Now, one of those individuals reacts to that situation. And
is there any evidence to believe that Mr. Lindsay knew that those people were there? Evidently, there was an interaction between Ms. Honky and the individuals in the parking lot. Keep in mind, this happened within a very short period of time, seconds. Is there any evidence that Mr. Lindsay even knew those people were there? Any direct evidence?
Yes, I think that it can be inferred based on the video, and I will point to the fact that he would reverse and he would stop. He would reverse and he would stop. Clearly, he sees the group of people, but he sees that they're not willing to move despite him trying to reverse into that parking spot. So to me, he knows that they're there, and he's trying to get them to move out of that parking spot, but they are not doing that. And legally, I don't think they have an obligation to do that. They were in that parking spot first. As the court may have acknowledged, there was an open parking spot directly in front of the one in question. The defendant could have easily just moved and taken that unoccupied parking spot. However, he did not do that. He decided to reverse into an occupied parking spot. And there was, I think at some point there was people knocking on the side of the door, bringing it to his attention. If the defendant's intent was to pick up his girlfriend and just leave, then why did he not do so?
Is that even an issue at this point in time?
Well, Your Honor, it goes to this.
People there for any number of reasons. He's backing in. What you are trying to say, what Mr. Lindsay had done was commit a felonious assault with a motor vehicle, and there's nothing to indicate that he had any direct specific knowledge. Evidently, Ms. Honky was out speaking to people. Mr. Lindsay was obviously the driver.
Well, Judge, to me, it's his.
With a criminal assault, you would have to show some type of an intent.
Yes, and the intent is the constant reversing, despite knowing that there's a group of individuals there. His intent at that point was to cause fear. Get out of my spot. That is the intent of an individual reversing into an occupied parking spot. He's using his vehicle in a manner that's not consistent with how vehicles should be operated and used. You don't use it to move people out of the way unless you're trying to cause them to feel in fear. And that's what he did here. And we know that's what he did here because one of the individuals standing behind the vehicle had reacted to that situation. He reacted. Mr. Dennis Keewan reacted to nearly being struck by this vehicle. He reacted. And what did he do? Well, Judge, if the situation was specific with Ms. Honky, maybe the witness, Mr. Dennis Keewan, would have approached Ms. Honky, but he didn't. He reacted and he went straight to the driver of the vehicle. And upon doing that, that individual, the driver of that vehicle, had exited. And he didn't exit alone. He exited with a firearm. as was displayed in the screen that was presented to the
I saw
court.
the video many times.
Yes, and now this is a point that I want the court to highlight for the court. When the defendant exited that vehicle, he didn't do so alone. He did so with a firearm, a weapon. And what he did with that weapon within a matter of seconds is extremely important.
Yes.
Because what he did was he took it and he pointed it at an individual's head. His intent was clear at the moment he exited that vehicle. His intent was, I want to shoot you in the head. And later on in the case, that's exactly what we heard, and that's exactly what we saw, is that the defendant fired that bullet, fired that gun. And where did he fire it? He fired it at Mr. Dennis Keewan's head. So his intent of causing fear on Mr. Dennis Keewan was displayed and stems from the vehicle. However, it continued. It continued when the defendant exited the vehicle, and it was clear to me when he put that firearm and pointed it at Dennis Keewan's head. And what brings it all together is when in the end, he now discharges it. He discharges it, that black handgun. And where does he discharge it? The head. The same spot he pointed to when he first exited the vehicle. He followed up on that threat, Judge.
That was after, of course, Mr. Lindsay was on the ground and Mr. Keewan was on top of it.
Yes, and
Evidently, that's partially off of you. It's not entirely clear. Certain things were clear from the video, but the times when the parties moved off of the clear view of the video against the wall, which was blurred, and the lens was covered with condensation, so it became not entirely clear.
yes,
Once they went against the wall, once it came out of camera view.
yes, you're correct, Your Honor. And there is some other events that transpired during this incident. And we learned that through Mackenzie Terrell and Miss Riley Girardelli. And what we learned from those two individuals, and I'll start with Mackenzie Terrell, is she identified the defendant. She identified him as as the individual that was choking Mr. Dennis Keewan. And in both the testimony of Mackenzie Terrell and Miss Riley Girardelli, they told us, and we learned from those two individuals, that the defendant, Brian Lindsay, was choking Mr. Dennis Keewan. We learned from Riley Girardelli that the defendant was strangling Mr. Dennis Keewan with both hands to the point to where he was purple. He was purple is what she indicated.
I have a testimony. Where was the gun, by the way, when this was happening? 2 hands around the neck. Where was the gun? Curious.
Judge, it's not clear, not every detail will be known to us. However, we're here just determining whether or not there's evidence of these charges. However, what we do know is that the defendant was choking the victim with both hands to the point to where he was purple. Now, where is Brendan Keewan in this interaction? The testimony by both witnesses suggests that Brendan was reacting. His father was trying to pull off this individual that was choking him to the point where he was purple. And so Brendan was reacting, trying to get this man off of his father. Shortly after that altercation, it leads to the defendant discharging his firearm a number of times, specifically 3 times. 1 bullet went through the head and the brain of Mr. Dennis Keewan. Another bullet struck Brendan Keewan above the chest area, right above his heart area, is what I believe the testimony suggested. And then there was a 3rd shot that went off. Now, that being said, the remaining events still play a very important factor for us when determining conscious of guilt. The defendant, instead of waiting around, letting the police come assess the situation, determine what happened, the defendant had fled. Now, he fled on a New Year's. This specific day was New Year's Eve, New Year's Day, and so
4 in the morning, New Year's Day. Yes.
yes. But the defendant had arrived there on New Year's Eve, around 10 p.m. the day prior. There was also testimony that he was drinking. However, I won't speculate as to anything in regards to his fleeing in relation to drinking, because I think
There's
that...
no evidence of intoxication.
Yeah.
We'll assume that everybody had consumed alcohol. I believe that was the testimony, but there's no evidence introduced as to intoxication. Nothing was...
Yes. And so I did want to highlight that for Brother Counsel, because we had a discussion about that. So I'm not going to argue that he was intoxicated, even though he was at the bar drinking New Year's Eve, New Year's Day. Our position is we don't know.
Yes.
And so that is it. But what we do know is that the defendant fled from the location.
Yes.
He was in the wind for 10 hours, Judge. And we also know...
What's the point you're trying to make with respect to this examination?
Yes, of course. I'd love to answer that. Leaving the scene after a shooting, to me, suggests that the shooter knew the shooting was unjustified.
No, I mean, he was afraid. He knew there's no question that he indeed shot the victims here.
I know. I think that it is a factor that can be considered, that fleeing the scene shows a guilty mind. It's a factor that could be considered. I'm not saying that that's what it is. It's just a factor that can be considered.
Again, we're talking about probable cause. We're not arguing to a jury. Yes.
I understand, but it's a factor of the intent to a degree. And so he fled the scene, Judge, and he did so for a while. What we also learned from Sergeant Cruz is that the defendant had contacted him. The defendant contacted Sergeant Cruz, and he informed Sergeant Cruz that I was just involved in a shooting.
Yeah.
And shortly after that, we learned that the defendant had turned himself into the police, and what was recovered during that interaction was a handgun. And that handgun was a 9mm handgun. And the casings of the bullet used at the alleged crime were 3 9mm casings.
For purposes of this preliminary examination, I don't think any of that is in dispute. What we call the Reyes Act, the facts underlying the charges are not reasonably in dispute. I think the only issue is here the existence of self-defense and what this court was going to do about it. I mean, there was a shooting of another individual, use of what would be deadly force. The question was whether or not there was justification by means of self-defense, but I think the core elements are not necessarily in dispute.
I understand. In Your Honor, as for self-defense, that is an issue that would be for circuit court to decide. But I feel obliged to just say that I feel that our position is strong in that aspect as well, but I will not waste too much of the court's time in regards to that.
I ask the parties to address before Mr. Wallace begins, and while you're still at the podium. There's been indication from the video upon the court's review that both of the alleged victims here, Mr. Dennis Keewan and Mr. Brandon Keewan, this all happened the operative events all happened in about 30 seconds from the time Ms. Honke confronted Mr. Dennis and Mr. Brandon Keewan behind the car to them approaching the vehicle to him coming out with the gun was about 30 seconds away. I counted. It appears from the video that Mr. Lindsay was sitting in his car and he was approached by Dennis Keewan and Brandon Keewan at the door of his car. Mm-hmm. Now, under the part of the stand your ground statute, but I will mention informally, and I believe that's 78951, does not, the law does create a rebuttable presumption if somebody is unreasonably removed from their vehicle, there is presumed to be a true and reasonable fear of death or physical injury so as to justify the use of deadly force. And that's the issue here, I think. And that was never addressed in the substance of the exam. I'm looking at the video for the first time, and then once we took a recess and I had a chance to view it a number of times, both Mr. Dennis Keewan and Mr. Brandon Keewan approaching at his door. There's some pushing and shoving at the door. And at one point in time, Mr. Brandon Keewan reaches in is actually pulling Mr. Lindsay out of his vehicle. All happens in seconds, but that's when Mr. Lindsay comes out with his gun and then began pushing backwards toward the wall of the bar where the shooting occurred.
Yes.
That is a statutory presumption of, if not self-defense, reason, the fear that would justify using deadly force.
Yes, and Judge, I'd love to respond to that. And that's an excellent...
And at this point, what do we do at preliminary examination, which is the next question altogether?
Yes.
See that? I noticed that the presumption.
And Judge, thank you for that question. And I don't know if the court heard this during the testimony, but I asked, I believe it was Riley and Mackenzie. I think those are the two individuals, but I know I asked the question. I asked them whether or not Mr. Brendan Keewan and Dennis Keewan were armed. And they both said no.
There was no issue whether or not they were armed.
Yes.
Clearly they were not. I don't think there's any evidence one way or another that even suggests that they were armed.
Yes.
That's not the issue.
I understand. That's just where I'm starting with my response. And so whether or not there was a danger that elevated to the point where the defendant had to use a weapon, I think does not exist because of not only those two factors, but we also...
Standing alone, that would be a legitimate issue whether he reasonably feared. But under the law, the statutory presumption, whether I agree with it or not, it says that if someone is being unlawfully removed from a dwelling, an occupied building, or a vehicle,
Yes.
the law presumes a reasonable and honest fear of death or physical injury so as to justify the use of it. It doesn't presume self-defense, but it proves a rebuttable presumption of the use of deadly force.
Yes, and there are three more things I want to touch base in regards to your question, Your Honor. Number one is Detective Hall testified in this hearing, and he indicated that he went through it frame by frame and was able to suggest that with a degree of confidence that the defendant was the individual that was exiting the vehicle. That was his position, his opinion, based off of what he did.
That's his opinion of the evidence, but the evidence speaks for itself.
Correct.
Probably 100 times myself.
Which makes me believe it's a question of fact.
I'm not necessarily disputing it, but that's a very important question of fact that I have to rule upon. Now,
Yes, of course.
Once the traditional elements of the assault with intent to murder are met, then the question comes whether or not there was justification, and once there is a threshold finding of justification, then that becomes an added element, a lack of justification, where the prosecutor has to show some evidence of lack of justification. That's where we are at.
Yes, and I do believe Lieutenant Hall's position and...
It's his opinion. It's not his testimony. His opinion doesn't control here. It's the court's opinion.
I understand, but his opinion is testimony, and the court can take his position into consideration when it's making that determination.
No, the court makes its decision from the facts. All right.
And moving...
I'm not ruling that it was or not, but I just want to bring everything into focus that we have the video displayed of the pushing and pulling at the door twice.
Yes.
The victims, and I'm referring to Mr. Dennis and Brandon Keewan as the victims here, but they approached the door. There was a pushing and pulling. There came a point where Mr. Lindsay sort of disappeared, was pushed back inside the door, and then it looked like Mr. Brendan Keewan reached in, and that's when Mr. Lindsay
Yes.
just looked the gun over his head.
And
It
Judge...
happens in seconds. Keep in mind, it was like 2 seconds, a few seconds.
Yes,
The whole
but...
incident was 30 seconds.
Yes, but Judge, what is clear is we cannot say with 100% certainty that Mr. Dennis Keewan, who approached the door, opened that door. We can't make that determination. So what we have to do is we have to look at the totality of the circumstances. And the circumstances in this case is that the defendant had reversed into an occupied spot numerous times, nearly striking the victim.
That's way before what I'm addressing here, and that's really not pertinent to my question. I understand what happened going in, and there was a lot of what I would call lack of good manners before this incident. But apart from that, I'm addressing what, irrespective of why these parties approached the door, I'm addressing that issue right now. The pushing and pulling at the door, and whether or not there was evidence of unlawful removal of a motor vehicle so as to trigger the statutory presumption of use of unreasonable, or excuse me, use of deadly force.
I do not believe that there is a clear record or any evidence to show with certainty that the victim in this case opened the door and pulled the defendant out of the vehicle. To me, it's unclear. I placed that at the record at the last hearing. However,
I don't think we addressed this at the last hearing, but anyway.
well, yes, we did. I mentioned at the last hearing that who opened that vehicle door for the defendant to exit was unclear to me. However, the OIC testified that he went through it frame by frame and was able to come to a conclusion with a degree of confidence that it was the defendant that was in the process of exiting the vehicle. To me, it's unclear from that video. He indicated that he went through, I think, a special software and was able to go through.
Special software is not before the court. We only have the video, and I have to.
I understand.
Don't interrupt me. I have to make my ruling based upon the evidence, not somebody else's opinion of the evidence. Ultimately, it's for the court to decide.
I agree, and I know that, but it's still a question of fact. If there, unless the court saw something that I didn't, that it's clear that the victim.
I'm not arguing.
Unfortunately, Your Honor, the victim is not. Mr. Dennis Keewan is not here with us today to explain to us what happened. He could have simply been wanting to just knock on the guy's door and tell him, "You almost ran me over."
You could
But
have been saying Happy New Year.
yeah, it's possible, but unfortunately, he's not here due to the actions of the defendants, and so I'll leave it at that. But the final thing I would like to mention is prior to the victim, Mr. Dennis Keewan, approaching that driver's door, the defendant could have drove away. So his intent of exiting with a firearm, to me, suggests that his intent was developed well before he even exited the vehicle.
In the 2 seconds. Again, this all happens within.
Judge, he almost ran him over. That's what led to all of the defendant almost ran over the victim.
That was before this all happened.
Before the shooting, but to me, he had the intent of felonious assault at that point. And so it could potentially be that Dennis Keewan was acting in self-defense. That's possible. We don't know with certainty, but we do know that the defendant's conduct arose to a felonious assault prior to the victim approaching that door.
And I understand your argument. Maybe you are delving too deeply into it, but I think that is a court issue that has to be addressed by the court because of the fact that self-defense is being legitimately raised. The threshold has been met for self-defense, and not only that, threshold has been met to the point where the prosecutor has to show some evidence that it was not self-defense standing alone, but then we have the added statutory presumption by the apparent or alleged attempt to remove Mr. Lindsay from the motor vehicle. So we have 2 presumptions there. They may well be a question of fact for the trier of fact, but I have to address them for purposes of my ruling because I have to make that threshold decision that, number one, the issue of self-defense has been raised, both the common law issue and the statutory issue by the removal from the motor vehicle, and that there is some evidence to rebut it to make it a question of fact by the trier of fact. Whether or not he was being unlawfully removed is a different issue. The law doesn't give no standard for what unlawful removal is, but I have to at least address the issue. All right. Anything else, Mr.
Yes. And Judge, we would rest at this point. I will just leave it at that. There's no evidence to suggest that the defendant was pulled from the vehicle, so that shouldn't be considered. That is our position.
You can look at the video and see Mr. Bilenstein was reaching in the car with his arm on Mr. Lindsay's coat.
To me, it's not clear that he was pulling him out of the vehicle. He could have been putting his hand on where the defendant was attempting to pull his gun, but to pull him out of the vehicle, to me, that wasn't clear. It could have happened.
Yes, I understand that there's a question of fact that we can see the arm reaching in. Maybe he's pulling, maybe he's pushing through nose, but that may be the ultimate issue.
Yes.
I'm not deciding one way or another at this point, but I can't not address address the issue because that is core to this case, whether or not there was self-defense and there was justification. There are two things, whether or not there was legitimate self-defense and whether or not there was legitimate deadly force. And the statute 971, 789, 71 doesn't go so much to the self-defense, but it's the elevated use of deadly force in the self-defense. The complaint with the victims here are not. They're both. Well, be that Mr. Dennis may not survive, but it's the use of deadly force, whether or not this is not a murder case, it's assault with intent to murder, but the issue is whether or not deadly force would be justified, and whether or not that's an issue. Once again, we go down that rabbit hole of trying to decide that case rather than just recognizing as that is an issue that has to be addressed, and the court has to find that there is sufficient question of fact to rebut the fourth element of assault with intent to murder, lack of justification. All right.
I understand, Your Honor.
That's what I wanted you to
Yes,
address. All right.
thank you. And Judge, one final thing just to clarify for the record. It's in regards to the eye of the victim, Mr. Dennis Keewin.
Yeah.
It's my understanding he's now woken up. I don't know if he's going to be back. Is he still sedated or is he fully awake? Do you know?
That's unclear.
So it's unclear. However, in regards to his eye, his two eyes, he has lost full vision in both eyes. And that right eye, I think there was an exhibit that was displayed to the court where it was hanging out of the socket. That eye was surgically removed, but the other eye was not.
Again, that's a personal concern of the court. How is that? That is a personal concern of the court.
I just wanted to clarify from the last hearing because there's a little bit of a misunderstanding regarding that on my end. So I just wanted to clarify for the record. Thank you.
Thank you, Your Honor. There was actually one thing that from the last hearing that I thought about as soon as we walked out of here. I was like, oh, I should have said it. And the court actually brought up that today about the testimony from Ms. Riley when she said that she saw Mr. Lindsay have both hands around one of the complainant's necks. That would be virtually, or actually not virtually, it would be impossible to have both hands around someone's neck and have a gun in your hand at the same time. And so I think that there's a little bit of I don't know. I think that the testimony is a little questionable based on that. Everybody knows each other. Everybody's trying to make sure that they make the story even worse. There's never any mention about Mr. Lindsay choking anybody or strangling anybody until the preliminary exam. And one person, in the effort to try to make that an even more a more egregious act by Mr. Lindsay, she says that he had she said he had both hands on the complainant's neck, which the court rightfully pointed out would be kind of impossible to do with a gun in your hand.
Irrespective of that, I don't want to get ahead of myself, but that can be argued each way. That versus Mr. Lindsay and greater fear.
I understand.
That's not an issue for this court.
I understand, but it was the testimony was that Mr. Lindsay had his hands on the complainant's neck, not the other way around. So that was where the question was. Mr. Lindsay, that's what. Yeah, they're saying two hands, but he also had a gun in his hand, which was clear. So that would make it very difficult for the work. The court did not want to address. Did not want to address what happened prior to the two complainants going to the car. I don't know if you still had that position, but Mr. Lindsay did pause several times trying to back up, and he paused with the hopes that the people that were standing in a parking spot would be polite enough to move as he was trying to back up, and he wasn't picking his girlfriend up as far as pulling up.
Well, within his rights, he's not testifying. You can't tell me what he was.
I understand. I understand.
I'm making the observation that there was no direct evidence that he had any knowledge of people or any animosity. There was confrontation between Ms. Honke and the people behind the car.
Right, and so that's.
The court can only infer knowledge from the movements.
Understood, Your Honor. Because the people were trying to add a count of felonious assault motor vehicle, that's why I was addressing it, because I don't think that they've shown that there was any intent to put anybody in fear. So that's why I'm addressing that that. As far as the presumption of being pulled out of your car, being reasonable, being put in reasonable fear for one's life and or great bodily harm, I agree. He was pulled. They went up to the car. There was no indication that Mr. Lindsay was even trying to exit his car. The door hadn't opened. He didn't roll his window. Nothing before the two complainants came up and forcefully pulled him out. The first time that they tried to pull, Mr. Lindsay didn't have his gun. The second time, Mr. Lindsay grabbed his gun. And and at that point, Mr. Lindsay hadn't done anything that he could even be charged with, because all he did was point the gun and I think his name is Brandon. And at that point, they both pulled him from his car into to the back of the car by the actual location. There's also a jury instruction, and I had it before. It was 7.24, where there's two people assaulting someone. That's that even heightens the when you have two people that are assaulting someone, that raises the fear of great bodily harm or death, because he was being assaulted by two people. In fact, he still has a lump on his forehead now from that assault. There's Mr. and he has a boot on his leg from that also. Both of these people were viciously attacking Mr. Lindsay. Mr. Lindsay didn't shoot when he first got out of the car. He didn't. Had to. He was being beaten, and had he not shot in order to get these people off, he would have been possibly dead from getting beat on that viciously. There's the fear of being pulled out of the car, even that they knew he had a firearm, they continued to attack him. And so the fear that someone does.
They may well be attacking because he had the firearm too.
Well, they started attacking him before that, Your Honor. So
I make these observations, but I have to reserve myself. These are really not the questions that I would address as the examining magistrate.
Understand, Your Honor. So I guess I would ask that, I would agree with the court about the presumption as far as being pulled out of the car, and to add to that, the being pulled out of the car by two men that continued to beat on him, and were beating on him while we're on top of him beating on him, and not stopping. And there's nothing that says that this is this is an unfortunate all the way around, and that's not, and I don't think that anybody's trying to say that, but the fact of the matter is Mr. Lindsay was being beat on by two grown men, and he protected himself the best way he could. He didn't get out of the car shooting. He didn't start this, and all he did was react to being beaten on. And as far as him leaving, he suffered serious injuries and probably wasn't thinking straight the entire time as he was trying to leave. And he talked to the OIC, said he was going to come in on Monday. In fact, came in later on that day. So he wasn't trying to hide from anything. He wasn't there wasn't a consciousness of guilt. He called in, he said, I did this, I'm going to turn myself in. He said Monday because he didn't, who knows why he said Monday, but in fact, he came in that day that he called, and was very forthcoming, brought his weapon, and I think, and I understand that self-defense is a question of fact, but for this is an extreme circumstance, which is obvious that Mr. Lindsay was not, in fact, the aggressor, and was simply trying to protect himself.
Judge, if I may briefly, thank you. Judge, to me it's very clear that the defendant was the aggressor. Also, we have to base our decision based on two things: the testimony and the evidence.
This is a preliminary examination, not the trial.
I understand, Your Honor. I just like to make my record.
No, I understand.
Thank you, Your Honor. And we need to consider we have to hear the testimony and the evidence. And there is zero evidence on this record suggests that Mr. Dennis Keewan and Brendan Keewan were the aggressors, and not just that, that they were beating on Mr. Brian Lindsay. On the contrary, we do have testimony by 2 eyewitnesses who indicated that Brian Lindsay was choking Dennis Keewan, and that his son, Brendan Keewan, what he was doing was trying to get this man off of his father. That's what the testimony was. And so that's what we have to base our decision on, not hypotheticals, not suggestions of what could have happened, but purely on the testimony. And the testimony in this case suggests that the defendant was the aggressor. He was the aggressor from the point he was driving that vehicle. He was the aggressor when he exited that vehicle, and he showed his intent clearly at that point by pointing a gun at an individual's head. And then he followed up on that threat by discharging the gun into Mr. Dennis Keewan's head. Now, Judge, it doesn't stop there. We also learned that the firearm that was discharged at the scene shot 3 9mm casings. Mr. Dennis Keewan turned over a firearm to the police, a 9mm that takes...
Is there any question of that that is that's the point I mean, there's no question that he shot the firearm. That was the 9mm that's turned over. I get all of that. But for purposes of our discussion, is that who is the initiator?
I think we've satisfied that portion. You're right. I'll rest, Your Honor. Thank you.
Anything else?
No, Your Honor.
All right, I'll step out for just a minute, come out in about less than 5 minutes with an opinion.
Thank you.
Thank you.
Please rise. It's now back. Maybe see. Anything further, Counsel?
No, Your Honor.
All right. Of course, for this, I've got some notes prepared, so bear with me if I sort of stumble a little bit. But I think it's important that we get a good factual basis for what we're doing here. Of course, by the way, this is a cliffhanger. I'm going to let the counsel know in advance that I intend on binding over on the charge of assault with intent to murder and the intended charges. So I'm not going to lead up to make that something that's dramatic in the end, but I think it's very important that I give a factual basis for doing that and address some of the other issues as well. The defendant here is charged with 2 counts of assault with intent to commit murder, as well as attendant charges of assault to do great bodily harm less than murder, assault with a dangerous weapon, and felony firearm, which flow from the initial charges. They are lesser included offenses, as well as cognitive offenses of the firearm violations. He's charged with those 2 principal offenses, which is really going to be the focus of my decision this morning. The principal charges of assault with intent to murder require the elements of intent to kill to the level of what would be second-degree murder, with the added specific intent of killing, not just to perform an act which would result in murder. The elements include the intent to physically injure another person, that he had the ability to cause an injury, and that he intended to kill the person. The 4th element, if there is a factual basis that the defendant had no legal justification or excuse, in this case it would be self-defense, which would be that justification. With self-defense being asserted and supported by the record, the 4th element must be addressed by the court. Generally, if the evidence of self-defense is presented to support to the levels to support a jury instruction for a jury, the prosecutor must prove some evidence to rebut the presumption. The standard for the preliminary examination in order to bind over is that there is sufficient evidence presented at the preliminary examination to support a jury instruction of self-defense, and then there must be sufficient evidence to rebut that. That may well be circumstantial evidence by the facts and circumstances involved here. The witness's testimony taken, and I'm going to say, in basing its decision, the court will address the facts and evidence presented at the examination. The testimony of the witnesses taken together merely established that there was indeed a confrontation or an argument between the defendant and the 2 separate shooting victims, and those are Dennis and Brandon Kerwin. I may refer to them as victims, or victims 1 and 2, or by the names. Please, in person, I mean not to be impersonal about it, but I just want to make it clear what I'm talking about. In any event, there was some type of a confrontation, argument arising at the door. A struggle occurred, arose. There was a struggle that led up to the rear of the motor vehicle against the wall of the bar, and then there were gunshots. I may mention this again, but I think that whole incident lasted about 30 or 36 seconds. Most instructive, and I think the core evidence in this case consists of a video that was viewed by the court, and it was introduced as an exhibit, and it was viewed repeatedly by the court in the course of its consideration. These reveal, in the court's view, the following. First of all, the defendant was the driver of the vehicle, described in this case as a Jeep, and I may refer to it typically just as the Jeep, so we're clear what I'm talking about. He was backing into a parking spot in front of the entrance to a bar at closing on New Year's Day morning, about 4 in the morning. There was a group of individuals, including the shooting victims, Dennis and Brendan Keewan, standing somewhere behind the vehicle on the passenger side toward the rear of the vehicle in the parking spot that the defendant was attempting to pull his vehicle into in reverse. These individuals were slightly off the adjacent curb, partially in the path of the Jeep and partially blocking its way. There involved a verbal interchange, what appeared to be a verbal interchange between the occupant of the vehicle, the passenger, identified as Miss Catherine Humke, who was outside the Jeep and engaged the individuals at the right rear of the Jeep. Once again, there is no audio accompanying the video. The court can only speculate and assume that it was a dispute. I think that would be a reasonable inference given the facts and circumstances that I've heard. Thereafter, both of the victims, both Dennis and Brenda, simultaneously walk around the side of the car and approach the defendant from the driver's side window of the Jeep. And at the same time, another individual from the group, and the court did note this, was at the passenger side window, evidently engaging Mr. Lindsay in some type of a verbal interchange. We don't know what was said. Nothing was mentioned about it, but it's significant to note that while Mr. Dennis and Brandon Cohen were confronting Mr. Lindsay at the driver's door, there was somebody at the passenger window evidently communicating with Mr. Lindsay in the same way that person was from the sort of group of individuals, not a friend of Mr. Lindsay, but evidently part of that group. Mr. Dennis Keevan approaches the driver's door, and there appears to be a pushing or pulling from either the inside or the outside between Mr. Dennis Keevan and Mr. Lindsay, the defendant here. It's unclear whether or not Mr. Lindsay was being pulled out of the Jeep or was pushing his way out, or a combination of both. Within seconds, the defendant exits the Jeep with the pistol holding above his in hand, raising it above his head. Thereafter, the defendant and the shooting victims, shooting victim number one in this case, Mr. Dennis Keewan, struggled toward the driver's rear side of the vehicle along with Mr. Brendan Keewan together. Mr. Dennis Keewan was being pushed from his front, and at the same time, Mr. Keewan was being pulled from behind by his jacket hood by another individual. It appears to this court that it may have been the companion, Miss Honky, but it's not clear exactly who that person is. But while Mr. Dennis Keewan was being pushed from his front by Mr. Lindsay, he was also being pulled by his hood from the rear by another individual who may be Mr. Lindsay's companion, Miss Honky, who testified in court, but that issue was not addressed. At some point in time, there was a struggle against the wall. It was not clear from the video. As I said before, the incidents, as they moved to the wall of the bar, they were out of the camera view partially, and was blurred, and the camera view was covered by condensation, making it clear what the court saw corroborated what was testified to, but it was not entirely clear. There came a point in time when Mr. Dennis Keewan, as he fell around, Mr. Dennis Keewan was evidently in a position over and above Mr. Lindsay. Thereafter, the parties engaged in some type of a physical contact that wasn't clear from the court from the video, but that corroborates the testimony of the individuals that the parties were struggling on the ground. At that point, the shooting did occur. Mr. Dennis Keewan was shot first. He was rolled off. Evidently, there was a struggle thereafter between Mr. Lindsay and Mr. Brandon Keewan, and there was another shot. Thereafter, the defendant drives away, and the court would note that evidently there was a passenger in the backseat of the motor vehicle. That was not mentioned in the testimony. Once again, this court can make its decision only based upon the evidence produced, but the court can't overlook the observation that during this entire incident, there was another person in the back seat of the Jeep. You could see him get in. At some point in time, Mr. Lindsay pushes him back in the vehicle, and the Jeep drives away with that witness in the back seat. So there are two potential witnesses the court observes of great interest to the court. Once again, I must make my decision only on the evidence presented. I can't speculate what that other evidence may or may not be. That's for another proceeding, but for this proceeding, I can only make my decision based on the evidence presented. Once again, there was no audio or video evidence to assist the court in evaluating this video, and I would note I may make reference to the case of People versus Sure, 350 Mishap, I believe it's 46, involving a case very similar to this. In that particular case, the defense presented a forensic audio video analyst We have no such assistance helping this court, so I have to make my decision only on the evidence presented. Now let's address the issue of assault with intent to murder. As I said before, the elements of assault to intent to murder require intent to injure an individual, an ability to cause the injury, an actual intent to kill, and lack of justification. In this case, that would be self-defense. In the Sure case, it involved a police shooting, so there were other issues of justification that came into account then, but this case only involves the justification of self-defense. As I said before, the prosecutor must prove not only the prosecutor must prove a specific intent to kill. Unlike murder in the second degree, that requires only a intent to do an act that may lead to death. In this case, there must be a specific intent to kill. That may be inferred from the facts and circumstances of the case. As I said before, not merely an act that would reasonably lead to death, but actual intent to kill. Intent is proven by other circumstantial evidence. I discussed the People versus Crawford. Assaulting a person with a drawn gun may infer that type of an action. Proof to intent to kill may be established by reasonable inferences. In People versus Warren, that was a case where a person had their mouth wrapped in duct tape. They were turning blue, and the court felt that there was sufficient facts to infer an intent to kill by the facts and circumstances of this case. Certainly, shooting towards somebody can't constitute an intent to kill, or to specific intent to do great bodily harm, less than murder. But actually shooting somebody in this particular case, actually shooting somebody in the head and in the chest, could reasonably infer the intent to kill, irrespective of why the intent of killing, but the intent to kill. And based upon that, there is sufficient evidence to show that there was an assault, with enough evidence to infer that there was sufficient specific intent to kill for purpose of assault with intent to murder. Now we enter the issue of self-defense, which is an added element. Once we have established that there may well be self-defense, the prosecutor must submit sufficient evidence to rebut that presumption. That can be brought by the facts and the circumstances of the case. Typically, it's hard to establish that level of self-defense or to rebut that. But the court feels that there were sufficient facts and circumstances, number one, to raise the issue of self-defense, and number two, to rebut that, because once the defendant left the car, there became the pushing and shoving, there's a fight against the wall, and there are a number of subjective circumstances which one can overcome or at least rebut the presumption, not the presumption of self-defense, but the issue of self-defense once it is raised. So the court feels that based upon the facts and circumstances of the case, there is sufficient evidence to rebut the presumption generally of self-defense, not only of self-defense, but the level of force. In this case, it was deadly force that was used. The person didn't die, but you have to show the intent to use deadly force to support the charge of assault with intent to kill. And the court feels that the use of what would be deadly force had the persons died, the court feels that number one, that would support the intent to kill. And the question of whether or not that use of deadly force is reasonable under all of the facts and circumstances of the case. That leads the court to another issue that must be addressed, specifically part of the Stand Your Ground statute. This would be MCL 780.951. The statute specifically provides that, among other things, it provides a number of things, but if a person is unlawfully, if the person is in the process of unlawfully removing an individual from either a dwelling, an occupied building, or a motor vehicle, there is a rebuttable presumption that that person had a reasonable fear for their life or physical safety, so as to justify the use of deadly force. We've seen the video, and there is a legitimate question of fact of whether or not Mr. Lindsay was being removed from the vehicle. The court spent a lot of time reviewing this, and the court cannot find no legal standard of what that may be as a matter of law and what may be used to rebut that. But that is a significant question as to the use of deadly force. But again, that remains a question of fact. In this case, it's the trial of fact. Once again, the court cannot find a legal standard that I can apply at this level as a threshold to say that presumption has been created and not rebutted. And looking at publications, it appears to be an issue for the jury, but if a jury found that there was an unlawful removal of the individual from the vehicle, then there is a presumption that deadly force would be justified. The court has to acknowledge it and look to it. I'm not overlooking it, but based upon my review, that remains a question of fact for the trial of fact. I cannot make that decision now and usurp the function of the judge and jury at circuit court. Typically, preliminary matters are made by the province of the evidence, and I think it would be inappropriate for me to view that as a preliminary matter unless it was just so obvious that no reasonable person can dispute that. And I look at that more as a decision to make the charge rather than a decision to bind over the circuit court. Finally, we have to address the question presented by the prosecutor. The prosecutor is asking the court to add a count of felonious assault by the defendant, Mr. Lindsay, using his vehicle as a weapon to assault the individuals in the parking spot. And the court's not unmindful of the fact that if Mr. Lindsay is deemed to be an assaulter, then that affects his ability to claim the right of self-defense. Irrespective of that, the court makes no finding that Mr. Lindsay had any actual knowledge of these people in the parking spot. The court viewed very carefully the tapes. The court sees that there is no inordinate speed or any overt motion of the motor vehicle that might be considered either negligent or criminal or assaultive. Once again, there is no direct knowledge of the defendant's intent to assault somebody with a motor vehicle. And quite frankly, it appears as if from my view is that the defendant appears to attempt to somewhat carefully maneuver in the parking spot with those people in it. And once again, we can see the car, we can see the people in there, but there is nothing in there that indicates that Mr. Lindsay was attempting to assault them or anything like that. There may have been a dispute, but once again, I don't think any reasonable person can conclude that Mr. Lindsay was in any way trying to assault those individuals or perform an act that could be assaultive. That was evidently the basis of the dispute, but I want to reiterate, evidently the dispute between Mr. Lindsay was with an occupant of the vehicle, Mr. Lindsay's passenger, Ms. Honke, and evidently the dispute that was being directed toward Mr. Lindsay arose from an argument that Dennis and Brandon Keewan had with Ms. Honke behind the vehicle, and there's no reason to believe that Mr. Lindsay knew anything about that until the people arrived at the side of his car, and another individual evidently was communicating through the other side of the car. Once again, individual on the group. This leads to obvious indicia of possible self-defense or belief that somebody was being threatened. But once again, that's a question of fact and a trial of fact, and that's something to be taken up at trial. It's a trial issue rather than an examination issue. But in conclusion, the court feels that there is no reasonable dispute that the defendant did indeed assault the two defendants. In this case, Mr. Dennis and Brandon Curran. He did it with the firearm that he used deadly force, that he shot the victim both in the head and in the chest. I think that raises the reasonable inference that by shooting somebody in the head, I'm going to repeat the obvious, by shooting somebody in the head and shooting somebody in the chest, that the court can infer the intent to kill, a reasonable prior fact may infer a reasonably that something less was done, but for the purposes of this charge, there is sufficient acts to infer the intent to kill. The court feels that the circumstances of this case raise the existence of the issue of self-defense. Number one, the ability to use self-defense and the level of force used, the use of deadly force. Once again, that's statutory. Without the attempt to remove somebody from the car, that would be based upon the facts and circumstances of the case, but there is a statutory presumption that requires that be applied. Once again, that can be removed from the facts and circumstances of the case. Obviously, there was a fight that led from the car to the wall, and there was a continued confrontation between the two, whether or not that resulted from the attempted removal or something else. When I say something else, the fight against the wall of the bar and what evolved from that has to be parsed out by a trial court. Once again, these are deep issues, and this is only a brief hearing on the preliminary examination based upon the prosecution showing some element of each of the crimes. What I'm saying is there are a number of other issues that need to be addressed. The court has to recognize them, but nonetheless have to be addressed, and it would be inappropriate to do it at this level. Some people may think differently, and if that happens, we will have to abide by that, but I don't want to ignore it or let the parties feel that to be ignored.
Thank you, Your Honor.
Mr. Mohammed, you're stepping up to the podium. I think you have something to say.
Yes, just thank you, Your Honor. And just to confirm, so the defendant is being bound over on all charges in the complaint, correct?
Yes, but not on the additional charges.
Yes, but so on count 1 through 12, he's being bound over on.
Yes.
Thank you.
Again, counts 1 and 2 are assault to commit murder. Counts 3 and 4 are the charges of assault to do great bodily harm, less than murder, lesser included offense, assault with a dangerous weapon, with the gun. Once again, a lesser included offense. Once you make the decision on the two principal charges, I think that those follow, as well as the firearm statute. I don't think there's any reasonable dispute that there were firearms used here. Having said that, counsel.
Nothing from the people. Thank you, Your Honor.
We've got another. I think the big issue here is that we have $1 million bond.
Your Honor,
I did not set that, but Mr. Lindsay is being held on a bond of $1 million.
yes, Your Honor. And I think after the court has heard the testimony and seeing how and seeing the facts as they have stood so far, Mr. Lindsay is not a danger to the community. This is basically a question that a jury is going to have to decide on who was guilty or not. But Mr. Lindsay was lawfully carrying a gun, which indicates he has no criminal record. And
Not dispute that he was lawfully carrying a gun. He was not wise. I make no feeling that by what I ruled today legally is any approval or.
I understand that, Your Honor. I'm trying to make a complete. So I don't believe that. And also,
No approval or personal justification or subjective justification. You have to make the ruling based on the law.
I understand, Your Honor, and I appreciate that. And I also would like to point out that Mr. Lindsay turned himself in a lot earlier than he actually said he's going to turn in. He contacted the police and he turned himself in, and he brought his firearm. And he was very diligent about doing that. He didn't have a warrant for his arrest. There's no legal reason why he had to, but he did come in and he faced it. And also, Mr. Lindsay has suffered severe injuries from this and doesn't.
I do not know that for a fact. Implication. I'm not criticizing, but I just want to clarify that is a representation being made to the court. Obviously, Mr. Lindsay has a right not to testify. He's here.
I understand, Your Honor, and I would have brought medical records, but I'm having issues with that. But the only reason I bring that up is because Mr. Lindsay does need 2 different types of surgery, and based on what has been after the facts have come out in this case, and based on Mr. Lindsay's family ties. He has family support here all the time. He's not at flight risk, and he's not a danger to the community to the point where he needs to be in county jail while waiting to resolve this case. I would ask that he be given a personal bond on tether, so he can address his medical issues and address fighting this case in the circuit court.
Yes, thank you, Your Honor. Judge, the only change in circumstances are that the court has now found probable cause for all the charges listed in the complaint. The defendant's being bound over on counts 1 through 12, so I would object. There's been no change in circumstances other than the fact that the court has now determined that the defendant did commit these crimes by a probable cause standard.
There's no reasonable dispute that he shot these individuals.
Yes.
I say that.
And number two, Your Honor, he fled from the location in this case, so he poses a potential flight risk. So therefore, I would object on that basis. Additionally, I do believe he poses a danger to the public. These two individuals that were shot, Mr. Dennis Keewan and Brendan Keewan, to my understanding, they don't know this defendant. This was a incident that was blown out of proportion clearly, and so my hesitancy to allow any amendment with bond is due to his potential danger. I feel that we have to protect the public from individuals that react in these types of manners, and so I believe that bond should not be modified at this time because I believe he poses a danger to the public as well as a potential flight risk. However, I hear Brother Counsel in regards to the medical injuries that defendant has sustained or may have sustained. We have no objection to marking the file medical so he can ensure that he receives all the medical necessities he needs.
I think that should go without saying.
Correct, but my understanding is the file is not marked medical, so I'm just requesting, based off of the representation of defense counsel, that the file be marked
Now,
medical.
Mr. Muhammad, you're saying no circumstances have changed. I presume that Mr. Lindsay was charged within 48 hours of this crime, was brought before a visiting weekend magistrate, not myself, $7 million bond based upon the sparse facts before it, but really didn't have the ability or the time to address these issues of self-defense and potential self-defense that affect the question of bond. Number one, was $1 million reasonable to begin with? It's certainly a remand bond. You can make a remand if there was a death. Short of death, there has to be showing that there is a clear danger and that there's strong evidence and a strong presumption. But in this case, we had the opportunity to look at the facts and circumstances of the case and I'm being reminded. People can't hear me. I apologize. A lot has changed evidence-wise. The court has had an opportunity to review that, and that does come into effect for purposes of setting bond. Mr. Muhammad, you're indicating that Mr. Lindsay was evidently making an admission of guilt by fleeing, but again, I'm going to characterize an angry mob behind him when he did flee. There's no question that he probably felt guilt for shooting people because there's no question that he readily admits that. The issue is self-defense, and nothing by the flight would indicate that he was withdrawing or not claiming self-defense. I'm just bringing that the issue here is not the underlying facts which happened, and I think everybody reasonably admit that what they call the actor's race, what happened here. This is not who done it. I hate to use that sort of colloquial way, but this is about why it happened. All right. And there is some evidence of the medical treatment, but I don't have any specifics on that. I think, given the facts of this case, a personal bond is unreasonable because of the facts.
Yes, Judge, we would strongly oppose a personal bond in this specific case.
That's not going to happen. I think. But I'm trying to come to a reasonable amount. Once again, $1 million bond under the circumstances,
Judge,
quickly, and I'm making reference to the court rules for setting bond. I'm going to make reference to 6106B and setting bond. The court looks to the level of evidence of guilt, if there is evidence of guilt or great presumptions here. The underlying fact, there's really no question about the guilt when it comes to who shot, but then we have a presumption of self-defense, which is a statutory presumption, so there is a legitimate issue that the court has to weigh in setting bond. And again, I think you can see the issue of self-defense, which is significant and not within what I feel is the jurisdiction of the court. Once again, you were going to say something? Yes.
Judge, we would have no objection to reducing bond to $500,000 cash with no 10% GPS tether house arrest.
Well, you didn't let me complete. We do have a referral from pretrial services recommending that a reasonable profit be $400,000. In similar cases, I set $500,000, but $4,000 is essentially the same thing. What is significantly different in this case is the presumption of self-defense and the facts and circumstances saying that that is a reasonable defense. I'm not ruling one way or another, and please do not think that I'm approving of the actions of one person or another, and that I feel that they were personally reasonable under the circumstances. But given the fact that other things being said based upon the charge itself, assault, intent of murder, without taking any of these other factors into consideration, a $400,000 bond would be deemed reasonable. I think that can be reduced further because of what I feel are significant issues that may affect the trial and the reasonableness or the likelihood of acquittal after everything has been considered, or even the reasonable likelihood of a reduction. So I think that a reduction of that is reasonable under the facts and circumstances of this case. So what I'm going to do is just set it at $200,000, cut that in half for no good reason other than we have to set it. I mean, there's a good reason for it, but whatever number I come up with has to be arbitrary. When I say arbitrary would be illegal, but there has to be some number, and I have to find some reason for doing it, using the $400,000 as a basis and considering all of the facts and circumstances that arose from the case, giving cause to believe that there may be a legitimate self-defense claim, and it's substantial. It's more than just I'm looking for the right word, but just a claim that's without basis. I think there's a substantial basis of that claim. Once again, irrespective of whether or not I agree with anything anybody did under the circumstances, I'm going to set it at $200,000 cash, no 10%. The reason I'm coming to that number is that I think it's makeable by either a surety bond or somebody can post the cash or get a mortgage. It's makeable. It's obviously a heavy lift, and under a man of Mr. Lindsay's circumstances, it might be no better than $2 million. There's a certain objective standard I have to set and a certain subjective standard I have to set. We're going to set it at $200,000, which may well be makeable. But once again, if somebody posts that for him, I don't think he's going to post it himself, but if there's a bond being posted or somebody posting it for them, they are going to assure their appearance in court. And once again, that would be makeable so that he can participate in his defense. There's no question this will take a year or so to actually litigate. I don't know how long things would take down there, but it'll be a substantial period of time. And given the circumstances of this case, I think to hold about $1 million bond or $500,000 bond, which may be essentially the same thing, $400,000 bond might be, the man with his circumstances may be a $4 million bond, but I think a $200,000 bond would be postable and makeable and assure his appearance in court to address the charges. Once again, obviously there would be the condition that there be a GPS tether, no use of firearms, no contact, all of the standard provisions if he doesn't. Again, I'm not using that ruling to in any way approve of anybody's actions here. I think it's a terrible tragedy that should not have happened. given the sound judgment of whether or not the person should have carried a gun in the first. But there are a whole lot of subjective reasons that makes this tragic, and nothing I say here should be taking sides or somehow signifying approval or approving the conduct of one person or another.
Yes, and Judge, I understand the court has modified bond. The only additional condition I would request in light of that modification is to include house arrest with the GPS tether. In the event that the defendant posts bond, we would like house arrest with the GPS tether be added as a condition.
Why is that?
Because I do believe he could be a potential flight risk. This case may turn into a homicide. It's still...
Everything I say has been preconditioned on that, and if it turns into a homicide case, the court may remand without bond, but may set bond for the same reasons I've said. The quotation I made from the court rule deals with cases of murder where the remand without bond is significant, except where the evidence of guilt is great, or the presumption, or the evidence, the proof of guilt is evidence, or the presumption is great. And once again, we've addressed the presumption. The evidence of guilt of the killing. I see the killing. I'm already jumping ahead of myself. Of the shooting is without a doubt. It's great. It's almost not in dispute. The evidence of what the case, the issue of this case is whether or not it is a legitimate case of self-defense, and the courts address that, and there is a significant presumption of self-defense created by statute, not by my own opinion, not subjectively, but under MCL 751, that if he's being removed from the motor vehicle, the law will presume that he has authority to use force, and we can't overlook the facts and circumstances of this case. That certainly leads one to believe that. Once again, I think that ultimate decisions for a trier fact and jury, but I can't ignore that, and I think it would be improper to hold him without bond, or a bond that would be the same as holding him without bond. And I'm setting the amount because I think it's reasonable. If I set up $500,000, might as well be $5 million. I don't know, but I think I'm setting an amount that is going to be a heavy lift to make. And I think if for some reason he makes it, he will be, or people will see that he's here. But given the strength of the presumption and the circumstances of this case, and I'm pausing for a minute because I cannot take into consideration what has not been presented. But I see that the other evidence, maybe sparse. I don't know what else is out there, but I note that one of the witnesses that evidently was in the backseat of the vehicle that may have seen everything. Backseat of Mr. Lindsay's vehicle, drove away. I'm not speculating. It's right in there, right in the exhibit, which has been admitted to the evidence here. There was a backseat passenger in Mr. Lindsay's car, and when the vehicle drove away, that drove away with it.
Yes.
I see that, and that cuts both ways, but that's something, an observation that you can't take into consideration. You have to set a reasonable bond. It's a high bond. That's a high bar, and once again, that should not be viewed as the approving of anything that's done here or my subjective belief in self-defense. It's just that this is an issue that has to be addressed. I think it's a significant issue, and that is a factor